Be ready. 5 seconds. No evidence has been recorded in the election petitions for the reason learned counsel for the parties conceded that the issue may be decided, treating that order dated 15/11/2003 as noted herein above was indeed passed by the returning officer, as also that the affidavit filed by S. Ranjit Singh did not comply with the requirement of para 2 of the affidavit prescribed as per form number 26 prescribed under Rule 4A of the Conduct of Elections Rules 1961. Learned counsel for the parties jointly submitted that the issue may be decided with reference to Section 101C of the RP Act 1951, as per which the election of a returned candidate is liable to be declared void on account of an improper rejection of a nomination paper filed by a person desirous of contesting the election. Section 33A of the RP Act 1951 reads as under: 33A. Right to information. A candidate shall, apart from any information which he is required to furnish under this Act or the rules made thereunder, in his nomination paper delivered under subsection 1 of Section 33, also furnish the information as to whether 1. He is accused of any offence punishable with imprisonment for 2 years or more in a pending case in which a charge has been framed by the court of competent jurisdiction. 2. He has been convicted of an offence other than any offence referred to in subsection 1 or subsection 2 or covered in subsection 3 of section 8 and sentenced to imprisonment for 1 year or more. The candidate or his proposer, as the case may be, shall at the time of delivering to the returning officer the nomination paper under subsection 1 of section 33 also deliver to him an affidavit sworn by the candidate in a prescribed form verifying the information specified in subsection 1. Conceding that the affidavit filed by S. Ranjit Singh was not as per the stipulated form number 26 and hence not in compliance with Rule 4A of the Conduct of Elections Rules 1961. Consequently, Section 33A of the RP Act 1951 was not complied with. Learned counsel for the petitioners submitted that the right to reject a nomination paper vested in the returning officer under Section 36 of the RP Act 1951 and that a nomination paper could be rejected only on the grounds stipulated in Clause A, B, and C of subsection 2 of Section 36 of the RP Act 1951. In exercise of its plenary power of superintendence, control and regulation of elections under Article 324 of the Constitution of India, the Election Commission issued the directions to the returning officers. The order mandates to the returning officers to reject nomination papers not complying with the said directive. Cognizance of the directive was taken by the Honorable Supreme Court in the decision reported as 2003 4 SCC 399, People Union for Civil Liberties versus UOI. The Honorable Supreme Court categorically held that no exception can be taken to the insistence of affidavit with regard to the matter specified in the judgment in Association for Democratic Reforms case. The argument that the only penalty of not complying with Section 33A of the RP Act 1951 is as prescribed under Section 125A of the RP Act 1951 holds no water as Section 125A operates in the post-electoral process.